order we see no reason to here. However, we take note of our earlier 2023 in SLP. So 40832 of 2022, page 161, requesting the High Court to consider the request for early hearing. In that view, we request the High Court to take note of the same and dispose of the matter as expeditiously as possible.
Or in case the matter can't be, then CM 2129 of 23 may be decided.
This main matter cannot be taken up for disposal. The High Court may also consider as to whether the application pending could be disposed of.
Application filed by the state government. Look, there's a larger issue which is pending before your lordships, but then petition 1397 of 2020. This is a slightly narrower issue pertaining to the compulsory.
Tag it along. Yes. Notice tag along with WPC number 1397 of 2020.
Lordships have issued notice. Deeply well. Well, I believe that is coming up shortly. Well, 11.2 talks about the establishment in question first charge. Here, admittedly, the one that I have purchased the loan from UCO Bank is a different establishment. The directors in the other one, which is in default of the Provident Fund, were also partners in this one. It's an 11.2 recovery notice which is 11.2 clearly says that in case the establishment doesn't pay and the promoter doesn't pay, the first charge
सभी लोग लाइक करते रहिए भाई, सभी लोग इसको लोग देखना लाइक करिए,
not on the promoter. Here what has happened is that
कमेंट करिए कमेंट.
I purchased it from UCO. We ultimately under SURFACE sold it. UCO initiated proceedings under SURFACE. We sold it. After the money came in, they came and said that we want a part of this file.
Correct, but what is due and payable there is the employees' provident.
Right, but my lords, today I am a secured creditor under SURFACE. It has a non-abstante clause in 26C. It says that notwithstanding any provision contained anywhere, and it's a later statute.
The employees' dues will take.
My lords, may I with respect, but someone will have to decide that. Please see 11.2. 11.2 talks about first charge on the establishment, not on the promoters. That's the clear wording of 11.2. My lords, we'll have to be ultimately guided by what the statute says. Now, two things are clear here. For a statute, it's a later statute than the Provident Fund Act, and after that, my lords, the provision which is relied on of the Provident Fund Act is 11.2 for the purpose. In 11.2, kindly see the wording of 11.2. I need to show three provisions to your lordships. Kindly first have 26C of the SURFACE Act. Just has that for a minute.
आवाज बंद हो गया है.
अपूर्व माइक खोल दो.
From UCO Bank. After that, assets are sold under the SURFACE Act. It's not that money is owed by me. I purchased the asset, then asset is auctioned as SURFACE permits me to do. And I realize what I have purchased as an asset reconstruction company.
You take as assignment as.
No, my lords, may I with respect say, please see three provisions and I'll leave it at that. Just have three provisions. Kindly first have 26C of the Securitization and Reconstruction Act, SURFACE. For a minute, my lords, 26C. 26. Capitally.
Directed to secure.
Yes. Priority to secured creditors, notwithstanding anything contained in any other law for the time being in force, after the registration of the security interest, the debts due to any secured creditor shall be paid in priority over all other debts and all revenues, taxes, cesses, and other rates payable to the central government and state governments or local authority.
Now, conduct also must be with
Manas, I just need to show. Provisions of this Act shall effect, notwithstanding anything inconsistent therewith contained in any other law for the time being in force or any instrument having effect to such law. And not be state of the which the note issued of the provisions of the subsection contribution deduction. Employees' punishment is not Rajesh Engineering, whose loan is high tech, which owed the money to the workers. So today, what is being done is the very
That was mortgage for that loan.
No, my lords, this was mortgaged to us under the Act. Under Bpsc, it was mortgaged to us.
It was mortgage to that loan, and therefore those dues are now being sought.
No, my lords. What is being sought is that the loan is
deposit 50%.
My lords, may I with respect say, ultimately we'll do whatever your lordship says, but may I only attempt to say this. My lords, I am a legitimate purchaser under the SURFACE Act, which I am entitled to. The SURFACE Act recognizes that I can purchase a loan. I have purchased the loan. The loan has been purchased from an establishment which does not owe any penny to it. The only commonality sought to be drawn is that these were also directors in other firm, which owes provident fund dues to its work. Now today, my lords, 11.2 I have straight away shown to your lordships to say that the first charge can only be on the establishment. The establishment is high-tech. The establishment is not Rajesh Engineering where I purchased the loan. So if I purchased the loan from Rajesh Engineering, the promoters for that gave a security therein, my lords. How does 11.2 come in? 11.2 is for the establishment. The PF dues are not from Rajesh. The PF dues are from the other company, my lords. The PF dues are not from Rajesh Engineering.
50%.
My lords, may I only say one thing, and I leave it at that. Would your lordships be kind enough? Something slightly lesser than 50. Because I'm not the defaulter of the loan. My lords, may I only would your lordships say 30-35%? And lordships, these are difficult times in these matters. Make it 30 to 35. 50.
Since the matter requires examination, issue notice to the respondent. In the meanwhile, there shall be interim stay of further proceedings of recovery against the petitioners, subject to the petitioners deposit 50% of the demanded amount with the provident fund.
Very good. Very good.
High Court plus watch the termination as well as blacklisting order after giving a finding that the show cause itself suffers from infirmity. Please see page 5 minutes.
See, after this you can go back to the
The question is
after this replying to the show cause, please send it.
Please see there is a finding of the tribunal which is affirmed by the High Court of Supreme. First see page 5 minutes. Page 5 last paragraph. But usually blacklisting records like show cause notice dated 27th of March 2020 does not reveal specific material information that there was a proposal to blacklist the petitioner for a period of 10 years. In other words, proposal is required given for number of years of blacklisting a person.
So that would be a ground. Let us say this
Let's please see one.
No cause notice can only be challenged on two grounds, you know very well. Only for lack of or malafide. Now it says I could reasoning is flawed. But anyway, ultimately justice was done. To start from the start. Do that. In fact, you had before this court, we would have stated orders. So be happy with the order.
Just one second. I understand. Just one second. There is a finding of the tribunal which is affirmed by the High Court stating that there is no fundamental breach. That's there. My lords will see page 50.
So don't make us to say something on this order.
I'm not leaving it. Then lords please. Permit me to withdraw it.
All right.
As an example, for the petitioner, seeks leave to withdraw the petition at this point of as withdrawn.
31 here. The High Court has reduced from 5 lakhs to 1 lakh. Said someone on basis of the judgment of this court. In fact, the early judgments were not 3 judges bench judgment of this court was not even.
31. Second last.
In effect, it's very my stand. Under 163A, what the High Court finds is the permissive user or the owner cannot even file a petition under 163A.
No, but you were writing the forward way.
But he's a permissive user. I am the employee of the contractor for whom I work.
That is not covered by the.
Yes, that's where
Policy.
that is where Lordship said 2019. Lordship had said 163A squarely applies for the legal class. But Lordship may kind of 2019.
On the policy.
163A says that the 1 lakh is a compensation for the in case of death. Well, in that context, you Lordship may kindly refer to 2019.
No, even assuming, see, even if it was under 166 also, you got
That is the distinction drawn by Lord's 2019 judgment saying it will be OTOs. The Lordship may kindly come 398. So 3 bench of this court may read. Further to understand to permit the insurer to raise the defense of negligence would be to bring a proceeding under section 163 on a par with proceeding under section 166. It not only be self-contradictory.
Not a negligence.
That's what the High Court says. Because
when assuming it was held also under the policy, since it was a borrowed vehicle, you would have got 1 lakh only. That's why that 1 lakh.
that is where what it says is not in case of death under second schedule of 163A, not is entitled to the death.
It's completely liable. It's not covered by policy. Already.
It is covered, but that's my case. In fact,
That's not question of negligence. We are only the liability.
correct.
How?
In fact, he has paid additional amount for comprehensive policy also. That is not only for
Para 9 of the High Court judgment, in fact, it has been considered that policy coverage.
That's where there's a mistake. But in fact, also
Application is relevant.
Why not? Should be.
Application is relevant.
Then sometimes I produce that policy because I will get insurance amount.
The petitioner.
Yes.
Bring on record additional documents.
Yes.
List there.
Great. We too I appear for the petitioner. So essentially, we had filed this petition by way of an intervention in a matter pending before the High Court. Now, what the clarification, what we wanted is, by the time your Lordship judgment had come, we had already conducted the exams. Now, having conducted exams, which was a composite for B.ed and D.ed. Now, your Lordship have consider only B.ed candidates. Now, our problem is, instead of holding a re-examination and all that, this exam what we have conducted, Lord B.ed will declare the result, will not appoint D.ed candidates, obviously, because the judgment is there. Now,
may I just note, we have filed an intervention on behalf of B.ed students, B.ed candidates. Now that they have also filed a petition, which is on Friday. For these selections, which had already been done before the Supreme Court judgment came, selection for this year, where
आवाज नहीं आ रहा भाई
पूर्व सर माइक अनम्यूट कीजिए
Just Niruddha.
it's already covered. The order is there with reference to
भाई अपना केस आ चुका है।
आवाज से बंद होता है तो आवाज नहीं आता, आवाज
केस आ
क्लियर
चुका है।
आएगा, थोड़ा सा वेट करके आएगा।
चुप रहिए ना भाई, आप लोग सुनिए ना, आवाज सही है सबका। वो चुप रहेगा तब आवाज कहाँ से आएगा?
सभी लोग B.ed BTC वाले जितने लोग हैं लाइक करिए, जितना भी लाइक कर सकते हैं, कोई भी हो लाइक करिए, शेयर करिए ताकि सब लोगों तक न्यूज जाए।
Otherwise, go to the other bench. If you want to withdraw, withdraw there.
Yes, I'll withdraw. Simple withdrawal.
There, registry to obtain appropriate orders. Honorable the.
No, I'll withdraw it. I'm saying I'm withdrawing it. Come now.
It is simple withdrawal.
Simple withdrawal. Liberty was for their favor. That I don't contest the re-exam.
Petitioner seeks
They don't want to
withdraw
fight.
the petition.
क्या हो जा जा
रुक जाइए अभी B.ed वालों के चेहरे पे थोड़ा खुशी है अभी वकीलों के, और B.ed वाले वकीलों के थोड़ा सा भी एक्सपीरियंस नहीं दिख रहा है।
अरे महाराज डिस्पोज हो गया, डिस्पोज कर दिया, नहीं देखेंगे ये सब। बताओ
एकदम हल
खत्म सर, हम बोल रहे हैं ना थोड़े है। जय श्री राम।
D.ed भाइयों को शुभकामनाएं। जहाँ तक D.ed जीत चुका है, जहाँ तक है, बाकी क्या होता है देखिए।
बोले थे सुनने नहीं किया।
केस डिस्पोज हो चुका है शायद।
आगे चलवाइए ना, हो गया।
अरे महाराज
हो गया केस अपना हो गया, बंद कर दो।
डिस्पोज कर दिया।
चलिए इस लाइव को यहीं एंड करते हैं।